Hello and welcome to the AIFC Court and International Arbitration Centre webinar series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 9 in our series. The topic is Corporate Restructuring and Insolvency under the AIFC Companies and Insolvency Rules and Regulations. Today's speaker is Tetyana Nesterchuk, a leading barrister from Fountain Court Chambers in London. As usual, we have 1 hour for today's webinar. Tetyana will give her presentation and we will then open the floor for questions. If I may, I'd like to ask you to type your questions at your convenience in the Q&A option shown at the bottom or top of your screens, and Tetyana will answer the questions at the end of her presentation. Thank you very much, and I'll now hand over to our speaker, Tetyana.
Good afternoon, everyone. Добрый день. Очень рада приветствовать вас на этом вебинаре. Очень рада, что у меня есть такая возможность с вами пообщаться в таком виртуальном режиме. Моя лекция, этот вебинар, будет проходить на английском языке. И в конце, как Крис уже сказал, будет время для любых вопросов, которые у вас есть. Я постараюсь на все их ответить в течение часа, который нам предназначен. Okay, I will now switch to English and say huge thank you to Chris for giving me this amazing opportunity to speak to you all virtually from the comfort of my own office and all the way in Kazakhstan. And I'm also very, very privileged to be amongst such distinguished speakers as most of the judges, I understand, of the AIFC Court, some of the IAC arbitrators, and some of the IAC user committee members as well. So thank you very much for this opportunity. My subject today is quite big, but hopefully topical. I want to talk about procedures which are available under the AIFC rules and regulations that are capable of allowing for a survival of a company in financial difficulties. One thing I will mention right away is that, of course, this procedure will be limited to AIFC participant companies. My understanding that at this stage, early on, there are already 450 AIFC companies to whom this procedure will apply, and the numbers will keep growing as we speak. Of course, the other sort of limitation is that this procedure only applies in the AIFC Court, and again, the practice of the AIFC Court keeps growing. I understand there have been some 87 cases already, which is a huge number, 2 judgments issued by the court, otherwise lots of arbitrations. So I'm excited to see where this goes, and I suspect there will be a lot of work in the court coming out of a lot of the COVID-related disputes that no doubt will arise in the next year or 2. So, apologies. Moving on straight into my talk. Here are some options. Apologies. Here are some options which will be available for companies in financial difficulties. The 4 main regimes that you will be looking at are, and this is probably in the order of sort of seriousness of your difficulties. First, you can make a scheme of arrangement. You can also make a company voluntary arrangement, and I'll explain the difference between the 2. You can go into receivership, or you can allow your company to be wound up, liquidated, in Russian bankrotство. But of course, I think the main aim is to avoid liquidation and to allow the company to survive. So there are different routes by which you can try and allow your company to survive. Where do you want to go? What do you want to look at? There is a plethora of rules and regulations, but I'm hoping to be able to take you through them today in a quick manner in the next 40 minutes or so, to give you a guide through them. So there are several sets of rules. When we're talking about schemes of arrangement, the main set of rules we'll be looking at is the AIFC company regulations, so it's that document. All of these documents, by the way, are available on the AIFC website, which is where I got them from, and they are based in English, which is the version that will be governing the court. but also translated into Russian for those who struggle with English or who would find a translation helpful. So you can have a look at the Russian version alongside the English as well. So we'll be looking at companies' regulations for the schemes of arrangement. When we're looking at the other three options, we will be primarily looking at the AIFC regulations, which is this document. And then for detail, we will be looking at the AIFC rules, insolvency rules, which is this document. So AIFC insolvency regulations and AIFC insolvency rules. For court applications, you'll also be needing to look up things in the court rules, and I will mention those as we go along. So we start with the receivership, and the reason I start with receivership is because I'm not intending to say a huge amount about it. What is a receivership? Effectively, it's not really a form of insolvency proceedings at all. It is a remedy that can be used by a secured creditor. And the reason why is that a secured creditor will be able to appoint a receiver. There's a difference between a receiver and an administrative receiver. So a receiver is somebody who's only appointed to administer the assets which are secured to cover the debt of the creditor who appointed the receiver. An administrative receiver is a person who is appointed as a receiver and who has control of the majority of the assets of the company. And the reason there's a difference is that a receiver will only have the functions and the powers which are given to him in the appointment by the creditor, so contractual powers. The administrative receiver will also have some additional statutory powers under the AIFC regulations. And those are set out in Schedule 1 of the regulations. The receiver, I said there's a role for the court, and the reason there is a role for the court is because the receiver will be able to apply to court to refer certain issues. So if there are some questions that arise, if the company or another creditor disputes the actions of the receiver will be able to go to court and say, right, I will refer this issue to the court, and it will be resolved finally. So the court plays an important role in the receiver's ability to administer the assets. This is more really a remedy that can be useful to the creditor rather than necessarily to the company, but it can also be useful to the company, the receivership, because it might well avoid the winding up, which is the second option that I wanted to talk about. This is very much a last resort for any company. From an unsecured creditor's perspective, and I'm unsecured because secured, of course, secured creditors have got lots of other different options. From unsecured creditors' perspective, this can pretty much be the only option. If you want your money back, you can apply for the company to be wound up, to apply some pressure on it. Effectively, what you have to do, you apply to court for an appointment of a liquidator, and the liquidator will be an insolvency practitioner. The liquidator then collects in and sells all of the company's assets and distributes the resulting cash. Sometimes he may distribute assets without selling them. And in the end of the process, the company is dissolved. So once all the money has been paid out, whatever is there, company is dissolved. There are two types of liquidation. They can be a voluntary liquidation, so a company can decide to dissolve itself, and that can be done by members or by creditors. Effectively, I think voluntary liquidation will always start with members' voluntary liquidation, but members are shareholders, but the directors of the company will have to give notice to the creditors, of course, that this is happening. The creditors then have a meeting. Both the shareholders and the creditors appoint a person to be a liquidator. If it's the same person, then that person becomes the liquidator of the company. If it's different people, two different appointees, then it's a liquidator appointed by the creditors who becomes the liquidator and then liquidates the company's assets. It can also be compulsory, and that is sort of that scenario where you are forcing, effectively you're a creditor and forcing a company to liquidate. and that can be done by order of the court. And I set out in my slides where you will find all the rules, because there's actually quite a lot of detailed rules as to how this can be done. So if that's something you're considering doing as a creditor, or if this is something being done to your company, then just go and have a look at the rules and see what can and cannot be done. And of course, I put down there's a role for the court. So this is in the AIFC regulations. A liquidator, again, like an administrator, can refer questions to the court. And so the AIFC Court will play an important role in any winding up or liquidation of an AIFC company, and that's under Regulation 46. And again, it can be all sorts of different questions that arise. So for example, if somebody wants to stop a sale of a particular asset, or if somebody disputes the way that assets have been allocated to different creditors, those kind of questions can all go to the court and be resolved finally, so that there's certainty for shareholders and for the creditors as to what's happening to the company's funds. The next issue that I'd like to talk about are schemes of arrangement. I think this is probably the most versatile tool that you can have in your armory as a company to help yourself through financial difficulties. The amazing thing about schemes is that none of the rules or regulations prescribe what can be a subject matter of a scheme. So first of all, perhaps it might be useful to explain what is a scheme. It is effectively a compromise or any other arrangement with creditors or shareholders of the company under the AIFC company's regulations, and it's under Chapter 9 of the regulations. So there's only about 3 sections. So there's not a huge amount of information in the regulation themselves on the scheme, but that really reflects the fact that schemes are so versatile and can be used for so many different things. One sort of salient feature, I think, of a scheme is that it is court approved. So AIFC Court becomes really instrumental in looking at the scheme, because there is no prescription and no limit to what a company can do, what sort of scheme it can propose. It is up to the court really to sort of police the scheme. And what do I mean by policing? I mean, the court will not go into every single detail, and the court will really rely on the advice that the company gets from its directors, obviously, but also from its advisors. So you would normally have your financial advisors, your accountants advising you on what to do. If you're in financial difficulty as a company, you will undoubtedly prepare accounts. You will go to your accountants. You might go to specialized financial advisors to ask for advice as to what you can do, how you can restructure your debts. And the reason why you'd want to do a scheme rather than talk to a particular creditor is if you have several creditors, let's say, and several different liabilities at different levels. So for example, you have to pay your rent, you have to pay your gas bill, electricity bill, which can be high. You have some loans from banks, you have to pay your shareholders because they're expecting dividends. And you think, right, I have all these payments to make this year, but there's no way I can make them. But I think business will return back to normal next year and I can make the payments then. Rather than negotiate with each and every single creditor, you can make a global proposal, hopefully on the basis of some financial advice, and no doubt you will be making some notes on what's happening, you will be making plans, financial projections. You can take that to all your creditors and shareholders and say, look, this year is going to be tough, but if you hold on and you don't liquidate our company, you will get your money and more. So that's why the schemes are so effective. And the court will look and make sure that the proposal that you're putting forward as a company is fair, reasonable, and represents a genuine attempt to reach agreement between yourself, a company, and your creditors and shareholders or shareholders. So you can't simply propose to take away some rights of creditors. You can't simply say, right, all the debts are going to be written off, I'm not going to pay you, but you just hold on there. That will not be a fair scheme. You will have to offer something in return. But other than that, there is no prescription as to what you have to do. And importantly, the company itself will be a party to the scheme. And there's a provision, it's part 9 of the company's regulations, the governing provisions. Here are some examples of when you can use a scheme. So it's not just an insolvency, it could be lots of different situations. So restructuring insolvent company, that's quite topical, or companies in financial difficulties. This is to enable you to avoid insolvent liquidation. You can use a scheme for a group reorganization. So for example, to insert a new holding company in the group or to move companies around the group, because you can use it for mergers or acquisitions. And in fact, there might well be a group reorganization when the two companies merge, or one company acquires the other, or demergers when the company splits up. So again, you can use a scheme, and you can propose to do something interesting with the shares and how you split the shares between the shareholders. That would be a scheme just with the shareholders. You wouldn't involve creditors in that. You can use a scheme to remove minority shareholders. Again, you can propose to buy back shares from minority shareholders or return capital to shareholders. So you can, one example of how you could do them, you could issue new shares to the shareholders, so a new class of shares, and then you can buy them back after having a court-approved reduction of capital scheme. So you can combine a scheme of arrangement where it's a reduction of capital scheme. You have to go to court for both, but you can do various interesting corporate structures with this. And certainly in my practice, I think about 2006, when just before the financial crisis and things were going very, very well, we've done a lot of these sort of schemes for companies to restructure, just to return money to shareholders, to make better sense of how the group is structured, to sort of simplify the shareholding structure of companies, etc. So they can be very, very useful. So how do you do it? The procedure is actually quite complicated, which is why, and the reason why it's complicated is because it's sort of, you have to flip between several places to figure out how it all fits together. But actually, once you've got the basic structure, you can go ahead and you can use a scheme for pretty much anything. So what you have to do, first of all, you have to apply to court to summon a meeting to vote on the scheme. So you have to make an application to the court, and then you've got to have a court hearing where court approves that you can have a meeting to approve the scheme. After the court approves the meeting, you then have to notify people, notify your shareholders, notify your creditors, whoever is involved in the scheme, whoever you want the scheme to bind. You have to notify everyone of the meeting taking place. And all the references to regulations are, just to be clear, are to the AIFC companies regulations. So you notify everyone under regulation 125, and let me just double check, and that in fact prescribes what a notice must contain, and so we will talk about it a bit later. Then there is a meeting or meetings of creditors and or shareholders, and it might be that you have to split different shareholders into different classes. So if different shareholders have different rights, for example, there might be 2 separate classes, and the same with creditors. So secured and unsecured creditors might form 2 different classes because, for example, your scheme proposes that they will have different rights as a result of the scheme. So you have all the meetings that you need to have, and then you go back to court. After the meeting, after the scheme has been approved, and the approval has to be by 3/4 of creditors in value, or 3/4 of the shareholders who are voting. So once you have the approvals of everyone, you have to go back to court and ask the court to sanction the scheme. So you have the second hearing, called the scheme sanction hearing, asking the court effectively to approve the scheme. Once you get the court's approval, and we'll talk about that hearing as well, you have your order, you go and then it's just mechanics. You go and certify that order by the registrar of the court, and you have to deliver that order to the registrar of companies. And there is in fact a sanction for non-compliance with that. So you've got to do your deliveries, all those administrative steps, you have to take them, otherwise you will be fined. And it's the applicant, it's the person who applies for the scheme who has to do it. So usually it'll be the company's directors. So make sure you do this. And then the scheme becomes effective actually on delivery of the order to the registrar of companies. So getting the order of the court is not the end. You've got to deliver it to the registrar of companies, which is when the scheme comes into effect. So it starts functioning. Until then, you don't have a scheme, you can't start doing anything. And then the registrar of companies includes the scheme in the company's articles of association. So that's a procedure. Now I'll talk in a little bit more detail as to each step of the procedure. First, we have your very first application to the court, and the regulation 124, the company's regulation, tells you who can apply. So it can be a company, it can be any creditor of the company as well. So that could be a remedy used by a creditor. If a creditor thinks that it will be in his or her interest to let the company survive, for example, they're owed a large debt by a company, which is due to be repaid over a period of 15, 20 years. And if the company is wound up, then the assets will never be enough to cover the debt. They will be more interested in saving the company. And so it might be that as a company, you go and talk to that creditor and you say, look, it's in both of our interests to allow the company to survive, but I've got a huge amount of other creditors knocking on my door and threatening compulsory liquidation. And any creditor, any unsecured creditor can apply for compulsory liquidation because you're unable to pay your debts when due. So they can say, you owe me a debt, pay me within 14 days. And if you don't pay, they have a right to apply for compulsory winding up. So in that situation, you can go to your biggest creditor and say, look, it's in both of our interests to do some sort of scheme. This is our proposal. Perhaps it makes sense for you to apply to court, for you to help us to do this. And then the responsibility and the financial, perhaps, burden of making applications could be shared between you and the creditor as well. Shareholders, any shareholder of the company can make the same application. And again, shareholders will probably be more interested in the survival of the company than any unsecured creditor. And then if the company is being wound up already, a liquidator is also able to propose a scheme. So a liquidator might think, well, actually, a scheme will be the best way of distributing companies' assets. So he or she can propose a scheme as well. What do you do when you apply to court? Well, you have to issue a claim form. How do you do that? Well, you have to go to the AIFC Court rules to find out. In these circumstances, you can issue what's called an abridged procedure. You can use what's called an abridged procedure under Part 23 of the court rules. And you issue an abridged procedure claim form. And I'll talk more about the detail of that. With that claim form, you have to file and serve written evidence. And again, I'll talk what that evidence will be. There's no need for any defense or reply, so it's just a claim form plus evidence that you will have to issue. So what does your claim form have to include? And this is set out in Rule 23.5. You bring a claim under, as I said, under the abridged procedure, and you have to explain in your claim form what you want the court to decide and the remedy which you're seeking. So in our case, where you're applying for a scheme, you're saying what we want the court to do is to convene the meeting to approve the scheme of arrangement, and I would recommend doing that. Also approve certain scheme documents, and I'll explain why it's useful to get the court to approve the scheme documents as well. You have to explain under Rule 23.5 of the court rules what legislative provision you're applying under, and in these circumstances you'll be applying under Regulation 124 of the AIFC Companies Regulation. Then if you are claiming in the representative capacity, what the capacity is, so if it's a director of a company, he will be applying as a director of a company representing that company. Obviously, a liquidator will be also applying in the representative capacity as a liquidator. Shareholder might, if it's a natural person, might be applying for himself, herself. It could be a company could apply in its own name, but if it's a director of a company, again, he'll have to explain that this is as a representative of a company. And then no, you don't need to name a defendant. So that's quite important, because I think sometimes it's confusing, because you think, well, how is this claim form? Well, you can just head it, as I set out my slides, in the matter of a company, the name of the company for which the scheme is proposed, under Regulation 124 of the AIFC Companies Regulations, and that would be the name of your matter. So that's the claim form. It doesn't have to be a long document. It just needs to set out, this is the information which absolutely has to be in the claim form, the stuff that's set out here. You can set out a bit more detail about the scheme, sort of 1 or 2 sentences explaining what the scheme is and explaining when you're convening the meeting and perhaps outlining which documents you want the court to approve. But there's no need to go into any further detail. One thing you would need to do is to supply with your claim form supporting evidence, and majority of your time will be spent preparing those documents for the court. So you'll have to submit a witness statement explaining to the court the scheme itself, the context of the rationale for the scheme, and I think that's really important, the explanation of the context, because as I said, the court will be deciding whether or not the scheme is fair and reasonable. And in order to decide that, the court can take into account the context. So you can explain that the reason why we're proposing this, the reason why we're proposing to pay less, for example, to our creditors and to pay less to our shareholders is because the company has suffered an unprecedented fall, for example, in its activities due to circumstances beyond your control. COVID is one of those circumstances completely beyond your control. But you think that this scheme will still be in the best interest of absolutely everyone involved, because it will allow the company in the long term to repay more of the debt than you would have been able to do had it folded now. So for example, you can say our current assets are X, our current liabilities are Y. Clearly, our assets are insufficient to satisfy all liabilities as they fall due within this year. And so we've got to postpone these liabilities. We've got to extend the time when repayment is due, for example, or we can't pay the promised dividend to our shareholders. They've just got to go without that dividend for a year. But in the long term, if they carry on being our shareholders, the company's profits will go up, and probably once we start making more profits, they'll be expecting to see higher dividends than they would otherwise expect in the following years. So you explain the rationale for the scheme, and also what you do with that witness statement, you use it to explain what the various scheme documents that you have prepared and which you wish the court to approve. So what are the documents? So first of all, you will have to send, as I said, a notice of the meeting to approve the scheme to your shareholders and your creditors if the scheme is for both. So your scheme notice will have to include the following documents: a letter, an explanatory letter from the company's directors or the company's chairman, whatever you have, to explain to the shareholders and the creditors what's happening and why this meeting is being called. And that's normally a short sort of 2 or 3 page letter written in very, very simple terms, just explaining what's going on. I think it's good practice to include an expected timetable of events, and we will talk about timetabling and the importance of setting up a timetable for the scheme. Obviously, you'll have to include the terms of the scheme, an explanatory statement, and this is a statement that's required under Regulation 125, so you absolutely have to include that, and I'll explain what that includes, and then the notice itself, the notice of the meeting. Sometimes you might want to advertise a meeting in the newspaper as well, so you can include the draft of the advertisement for the court to approve, and in proxy forms. I'm not sure whether you're aware, under the AIFC company regulations, and I'll get you the relevant provision in a moment. I should have written it down. I think, yes, it's Regulation 102. Under Regulation 102 of the company's regulation, the company must ensure that shareholders are notified that they don't have to attend the meeting themselves. They can appoint another person who doesn't have to be a shareholder to be their proxy to come and vote on their behalf at the meeting. And so what a proxy form is, it's a form which a shareholder can sign and send to the company, notifying the company that he or she will be appointing a proxy to vote on their behalf. And that's normally quite convenient, especially in the times of COVID, when there's still social restrictions. It might be very useful to appoint a company who is a proxy agent. I mean, there are plenty of companies who do this sort of services, literally to turn up and vote on your behalf, and you tell them how you want to vote. You tell your proxy how you want to vote, and that's what they do for you. So proxy forms have to be drafted, and it'll be useful if they're approved by the court. And the reason I say it's useful to include all these documents in draft and to have them approved by the court is that then there is no question when you come to a second court hearing to sanction the scheme, there's no question that something hasn't been done in accordance with the law, because here you've done everything that the court has already approved you to do. So all your following steps have been pre-approved by the court. So this is how the hearing will go. It would normally be a short hearing. There will not be a defendant. You just turn up. You don't have to be represented by a lawyer. Any director of a company or any lawyer of the company can come to the court and just explain what they're doing. All you have to do is explain to the court what the purpose of the scheme, take the court through the documents, explain what each document is and what you're asking the court to do. And effectively what you'll be asking the court to do is to approve the fact that there will be a meeting of creditors and or shareholders and to approve some scheme documents. What is the court going to be looking at? At this meeting, they're simply looking at whether the scheme has a chance of being approved. So that's question number one. And then whether the proposed division of members and creditors into one or more voting classes appears to be correct. And that is actually a huge area. I've already mentioned that you might want to split people into different classes depending on the rights they're going to have under the scheme. So that's one of the areas the court will consider. And then importantly, the court is not at this stage looking at the fairness of the scheme at all, just looking at whether the scheme has a chance of being approved and whether the division into classes appears to be correct. And then they say the judge may but does not need to approve the following documents. Other than document, you might also want the judge to approve the notice period for each meeting. And the reason I say this is that while the notice period for the general meeting of a company is specified in the company's regulations, there is no such specification for a notice period for the meeting to approve a scheme. I would say you would not, so you'd need to suggest your own notice period. I would say it's safe to go for 21 days because that's the notice period for the general meeting under Regulation 97. It could be a different, shorter period if you have a period specified in your Articles of Association, for example. If your articles say 14 days is enough, then that could be sufficient. But effectively, what you're trying to avoid is any shareholder or creditor turning up and saying, actually, you gave us too short a notice. We had no idea this meeting was happening. And so the scheme that the meeting approved can't be lawful because you didn't give me sufficient notice. If you actually talk the court through the notice period and the court approves it, then it'll be so much harder for anyone to argue that your scheme is not lawful because notice period was not sufficient. So I would say that's helpful. Usually, well, not usually actually, but quite often, if you're doing schemes other than for insolvency purposes, there might need to be a meeting of shareholders to approve certain things. So if you need to issue new shares or reduce capital, there'll still have to be a meeting of members. And so actually you'll go for 21 days because usually the court will say that the court meeting to approve a scheme and any general meeting of shareholders should take place on the same day. And that's just because it's convenient for everyone to turn up to just one meeting effectively, which would do several things. So I'd say 21 days is probably what you're looking for in terms of a timetable. And then, as I said before, you have to include the explanatory statement with your documents, and it'll be helpful for the court with your documents that go to your shareholders and creditors, and it will be helpful for the court to approve the draft of that document. And here is what that document has to contain under the regulations. So we haven't got a huge amount that is prescribed in the regulations as to the schemes, but we are told what the explanatory statement has to contain. And that's an explanation of the effect of the arrangement. So what effect it will have on everyone. Any material interests of the directors, and that is quite important. So to the extent directors are benefiting from this arrangement, that has to be told to everyone. If there's any debt securities issued by the companies, how it would affect the rights of debt securities holders, and any other matter that has material impact on the company, creditors, shareholders, and debt security holders. So it makes sense to spend a bit of time drafting this and making sure that it complies with all of these requirements. And then this is the evidence, other evidence that has to be contained other than explanatory statement. I think I've already mentioned the chairman's. Actually, no, this is now, we're now moving on to the court hearing too. So once you've, before we move on to the court hearing, I'll talk a little bit about the meeting of the shareholders and creditors. Once the court has approved summoning a meeting, you issue the notice with all of your documents that have to go to shareholders and creditors. You wait the relevant amount of time, and I would say you have to send all notices to shareholders directly, and I would say it probably makes sense to have an advertisement as well. So just so that no one can complain that they haven't realized this is happening. Here in the UK, the Financial Times have got pages and pages of advertisements at the back advertising companies' meetings. I wonder whether something similar will exist in Kazakhstan, whether there is a sort of a financial newspaper where you can publish your advertisement, or perhaps some sort of circular by the AIFC Centre where you can publish your advertisement. But I think I would recommend publishing an advertisement as well. And then you have a meeting, and as I said, the scheme must be approved by at least 3/4 of creditors by value, and then 3/4 of shareholders, if it's a scheme with shareholders, 3/4 of shareholders voting and present at the meeting, and of course that includes voting and present by proxy. So shareholders who are not, so it doesn't have to be 3/4 of all of the shareholders of the company, just those who actually turn up. So that's quite important, and that's why notice is really important. And once you have that, you've got to start preparing for your second court hearing. And I would say you'd probably be preparing for your second court hearing even before, during that period of lull, sort of 21 days you have when you send out all the notices and waiting for the meeting to take place, because you will be assuming, and hopefully you would have been talking to your shareholders, your biggest creditors. You'll be talking to them behind the scenes, you'll be explaining to them what you're doing, you'll be trying to drum up some support, and you will have a good idea of whether or not the scheme will be successful, and you'll be preparing for your second court hearing. You'll be setting up a date with the court, and you'll be starting to prepare your draft chairman's report of the meeting, reporting on what took place, how many people turned up, who voted, how they voted, and then you'll have to have a witness statement or an affidavit confirming that the scheme was approved by the requisite majority and the numbers of those present and votes cast at the meeting. And then you go to court and you have your second hearing, and it is at this hearing that the court will consider whether or not the scheme is fair and whether it's reasonable to approve it. And so what is the court going to look at? Here is a quote from a very old case, but I think the court would still be, the IFC court would still be thinking along the same lines, be looking whether the proposal is such that an intelligent and honest man and a member of the class concerned, acting in respect of his interests, might reasonably approve. So what the court will be looking at is to make sure that the scheme is genuine and the people haven't been bullied into approving the scheme. So they'll be exercising some judgment as to whether people have actually been acting free of their free will, and this is something that they would have approved of their free will, rather than sort of coerced by the company into approving it. It'll be looking at whether each class was fairly represented by those attending the meeting. I think some people would say, well, if just one person from a class comes to the meeting, perhaps a class has not been fairly represented. But if actually there are only 2 members of the class and one of them turned up, then you could argue, well, it was fairly represented because there's only 2 people and there's nothing we could do to make sure that both of them turn up. We can't ensure 100% attendance. But the court will be looking, if it's a class consisting of 200 people, for example, only 2 turn up, the court might be concerned that there was not a fair representation of the class. Then whether the statutory or the laws have been complied with, so correct notice, proper dispatch of the explanatory statement, but hopefully the statement had been approved, so nobody would be looking at the terms of it just to make sure that it was actually sent. And again, you've got to cover that in evidence. You've got to say in evidence, this is how we send everything. This is where we advertise the meeting. And these are the numbers that have turned up. And it might be that in the evidence, you'll have to say, okay, well, on the class representation, you might have to say, well, we only had 5 out of 50 people turn up, but there might be very good reasons. And the 5 who did turn up actually represented, I don't know, 90% of the debt or 90% of the shareholding. So whilst you have 50 shareholders within a class, 5 of them hold 90% of all the shares. And so you'll say, well, that was a fair representation of the class. The court will look at whether the scheme complies with the law, and that's just general law, and there's nothing fraudulent in the scheme, that what you're doing is not unlawful. For example, you're not trying to evade tax through a scheme, that sort of thing. That the scheme is not subject to any subsequent conditions. So usually it's not a good idea for the scheme to be conditional. So you can't say the scheme will be implemented only if these conditions are met. I think court will struggle to approve the scheme. They would want to know that the scheme can be implemented as it is right now. And then that the scheme is actually needed. So that's quite an interesting question. There was one case back in the 1970s here where the court refused to sanction a scheme whose sole purpose was the avoidance of stamp duty, which is a form of tax on property here in the UK. So the court might say, well, if the sole purpose of your scheme is to avoid tax, then maybe perhaps it's not needed. And I suspect it will fall under the law compliance with the law provisions as well. So that's something to think about. Whilst I said that the subject matter of a scheme can be anything you want, I think the court might raise an eyebrow if what you're trying to do is to avoid compliance with some law. And this is, I cover here on the slide the issue of class constitution, that I'm not sure we'll have a huge amount to go through, but you'll be able to see through the slides here what constitutes a class and whether a class is correctly constituted. There's a lot of learning, as I said, on this. If the court finds that the class has not been correctly constituted, we may find that it has no jurisdiction to sanction the scheme, and you'll have to start all over again to constitute the class properly. So it's up to the applicant to determine the classes. So it's something you need to think about in advance quite carefully. Dealing with changes of circumstances, again, quite important. There might be changes of circumstances that you'll have to communicate to various people, to your creditors and to your shareholders. What do you do in order to deal with it? All depends on the timing. So if it's before the first court hearing, then just put it all into the court documents, and that's easy. If it's after the dispatch of the scheme circular, consider whether you need to issue an update. If it's after the second court meeting sanctioning the scheme, you've already had all your approvals. Well, how serious are the changes? Are they really material? Is it something that means that you have to go back to court and tell the court, look, this happened. Do we need to go back to our shareholders and creditors to approve this? And the material change could be, for example, a director's interest in the scheme changes. So that could be considered a material change. And here I set out sort of all the steps that you need to take, and I won't talk you through them, but I think it'll be helpful for you to just look at the different steps in order for you to do your advanced planning. I would say on average, you would need 1 to 2 months, probably closer to 2 months to implement a scheme. So if you're thinking about it, you need to get moving, just because you will need to have time for 2 court hearings, which can be scheduled at short notice, and there will be short hearings. There'll be sort of no more, I would expect, than 30 or 40 minutes for a hearing, especially if you explain everything properly in your documents. I don't think the judge will need to spend a lot of time with you at the hearing to be talking about these documents. But you still need 2 hearings, and you will need to have a day of meetings, and you will need to have about 21 days notice for the shareholders to have the meeting, and some time to prepare your documents. So I think overall, from you starting to think about the scheme to the scheme becoming effective, you'll be looking at about 2 months. So just think ahead. And that's all I wanted to say about the schemes. And the only other topic I wanted to cover very quickly are the company voluntary arrangements. And the difference between these arrangements and the scheme of arrangements is that these are usually used or really only used in this insolvency type situations. So when you are in financial difficulties, and this doesn't have to be court approved. So this is just a compromise between the company and its creditors. This compromise binds all unsecured creditors, but it does not affect the rights of secured or preferential creditors. Preferential creditors, for those who don't know, there's a regulation specifying who preferential creditors are, and it's essentially your workers, people to whom you owe salary, plus payments into pension funds. The beauty of the CVA, as they're called, is that you can apply for a moratorium. And what the moratorium does is gives the company breathing space. If you apply for a moratorium to the court, so the court is involved through this application for a moratorium. If you apply to the court for a moratorium, it means that nobody can bring a winding up petition against you. Company can't go into receivership, so no creditor can appoint a receiver. Company shareholders can't do anything. They can't just summon the meeting and try to do something that directors don't want. So you're very much in control, and you're given some breathing space really to deal with your financial difficulties. So a CVA can be useful if you don't have as much time as would be needed for a scheme. You need something to happen straight away. You can do the CVA, but even with the CVA, if you need that moratorium, you still need time to go to the court to obtain it. So this is the outline of the procedure. The directors appoint a nominee. The nominee then prepare prior to appointment, they'll have to prepare and give the nominee a proposal for a scheme. So you still have to spend time to preparing the proposal. And within 7 days of giving the nominee the proposal, you also have to give the nominee a statement of affairs. So I have references to regulations and rules here. So regulations, we're still in the AIFC insolvency regulations here, and the rules are AIFC insolvency rules. So you have to flip between the two to figure out how the CVAs work. So the rules set out what's got to be included in a statement of affairs, effectively telling the nominee pretty much everything about the company, the debts, what it owes, the dates, etc. Then the nominee will call 2 meetings of a company, i.e. the shareholders, and then of the creditors, who will consider the CVA proposal. There'll have to be notice of the meetings, and the notice must contain the director's proposal, the statement of affairs, and the nominee's comments on the proposal. Then you'll have the meetings, and again, the resolutions for an arrangement will be passed by a majority of more than 3/4 in the value of creditors or shareholders present and voting, and these are the relevant rules and regulation. If the company is eligible, then the directors can prepare a proposal for a moratorium, and that proposal can be part of the same document as a proposal to the nominee for the scheme itself, and needs to explain why moratorium would be beneficial for everyone. And as I said, it's simply to give breathing space. And then the nominee will have to make an application to the court. So it's not the directors, it's the nominee who have to do this. The role of the court is not limited to the moratorium. So if the CVAs that are approved at 2 different meetings of directors or of creditors and shareholders differ, then any person who appears to the court to be interested may apply to the court to decide which of the CVAs is to be taken as approved. And that is specifically wide. So it says any person who appears to the court to be interested. So it could be any shareholder, any creditor, and I would have thought any director as well. Any director of the company could be a person interested. Possibly the nominee himself. Not possibly, I would say the nominee himself would also be a person interested. I'm not sure wider who else would be interested. It could be that one of the secured creditors who doesn't need to approve the scheme might be a person interested who would go to court. And then once approved by the meeting, and if the proposal is approved by both meetings without changes, well, that becomes the approved CVA, and then from that moment, it becomes binding and takes effect, and it binds every person who has notice of and was entitled to vote at the meeting. So that's why notice, again, very important. As long as you've sent notice to everyone, it binds all the shareholders you've given notice to, binds all the unsecured creditors. Can't bind secured and preferential creditors, as I've said. And then Once the CVA takes effect, nominee becomes a supervisor of the CVA, and anyone who's dissatisfied with what the supervisor does can again apply to court. And then finally, once the CVA is completed or terminated, within 28 days, supervisor may send all creditors and shareholders of the company who were bound by notice the CVA was fully implemented or has terminated. And that notice must be accompanied by the supervisor's report summarising all receipts and payments made by him in connection with the CVA, or explaining why the CVA has terminated or somehow departed from the terms that were approved. And finally, on the moratorium, very quickly, there is an eligibility requirement for a moratorium, and that's set out in Rule 3.4 of the rules. Not every company is eligible for a moratorium. There are some notable exceptions, all set out in Rule 3.4.1. So some exceptions, for example, are for companies that carry out contracts of insurance, or companies that accept deposits, banks, effectively. Companies which are investment intermediaries, and I think the most interesting exclusion is any company that has liabilities under an agreement of more than $20 million. So you can't apply for a moratorium if you have huge liabilities. And then the effect of the moratorium is set out in Rule 3.5, and as I said, it's just a breathing space for the company to implement the CVA. So whilst the CVA is in effect, nobody can apply petitions for a company to be wound up, no creditor can appoint administrator, no resolution can be passed of the company, so no shareholder can intervene, etc. So that is a quick canter through, I'm afraid, the rules. And I've left only 8 minutes for questions, but I hope I can deal with them. And if I can't during the session, then I'll try to answer as many as I can in writing.
Tetyana, thank you very much for that really superb and valuable presentation. If I may, I'm going to read out a couple of questions and for you to answer. So, first question. In your presentation, you pay attention to the difference between receiver and administrative receiver. You also mention liquidator. Is liquidator a term equivalent to administrative receiver, or is it a different term? If a different person is implied under liquidator, can you please explain this person's role or authority in the course of a company's liquidation?
So it's liquidator is a different person. So a liquidator is only appointed when a company is being wound up. What receiver does, receiver only supervises the assets that have been secured by the creditor who appoints him. So receiver can only be appointed by a secured creditor, and secured creditor will normally have some sort of security. So the receiver will only be responsible for the assets that form part of the security. An administrative receiver will usually somebody becomes an administrative receiver by virtue of effectively having responsibility for the majority or the majority of the assets of the company. And that receiver will have additional powers under the statute, under the regulations, which are set out in Schedule 1. So effectively, power to take possession, collect relevant property, sell, otherwise dispose of property, raise or borrow money, appoint lawyers, etc., etc., refer any question to arbitration. So those are the kind of powers that the receiver will have. An administrative receiver will have, and that's Schedule 1. And then the liquidator, the main difference is that administrative receiver and receiver are appointees, and their powers are contractual, and you can, a creditor who appoints them can prescribe what their powers are in the document appointing them. A liquidator is somebody appointed by the court. I should say that both liquidator and receiver, administrative receiver, all have to be insolvency practitioners who are registered with the AIFC. So they all have to be insolvency practitioners registered, and that is prescribed. The way you can register, I think, is set out in the insolvency regulations, I believe, but I'll have to double check that. I've seen the provisions somewhere. The liquidator, the powers of the liquidator are purely prescribed in the legislation. So Schedule 2 of the AIFC insolvency regulations sets out the powers of the liquidator, what the liquidator can and can't do. And as I said, a liquidator can, for example, make a proposal for a scheme of arrangement of a company. So liquidator's powers are much wider than administrative receivers, for example, because he effectively has control of the whole, or she will have control of the whole company, can call in all of the assets and can do pretty much anything they want with the assets and distribute them how they see fit. So they have the power to pay any class of creditors in full, power to make any compromise arrangement with creditors or persons claiming to be creditors, powers to compromise debts, powers to bring any legal proceedings or defend any legal proceedings on behalf of the company, and even power to carry on the business of the company as far as may be necessary for its beneficial winding up. So huge powers of the liquidator, and that more restrained powers of the administrator, and that's Schedule 1 and Schedule 2 of the AIFC insolvency regulations.
Thank you, Tetyana, for that answer. Before I ask the next question, I would like, if I may, to pass on a comment from our Chief Justice at the AIFC Court, Lord Vance, who has expressed his thanks for your very clear exposition, and very valuable to have this before the difficult post-COVID times.
Thank you. I'm very grateful for Lord Vance.
Moving on to our second question. If an asset of a company being liquidated is distributed to the company's shareholders without being sold, as you mentioned, how will the value of such assets be determined in such a case?
Well, that's an interesting question. I'm not sure there's anything in the regulations which tells you the answer to that. So I might have to go to the case law to have a look. I would have thought that you'd have to have an independent. I would have thought that you can't just decide unilaterally as a director that this is the value I'm going to attribute to the asset. And I can see why that question has been asked. If the shareholders are sort of persons connected to perhaps the directors of the management, it might mean that what you're doing is effectively passing on all the assets of the company to the shareholders, and the company winds up, doesn't pay its creditors, and becomes a new company overnight. I think you will have to make sure that you have a professional valuer valuing the assets, because certainly anyone else can apply to the court to dispute what's being done, because anyone can apply to court, well, anyone interested, certainly somebody like a creditor will be able to apply to the AIFC Court to dispute a particular distribution that's being made here. So if an asset has just been passed to shareholder, a creditor might well go to the court and say, I'm sorry, I wonder whether the administrator should have done that, and on what basis, given that the value of the shares is X, but the asset, I think, is valued much higher. So a creditor can obtain, for example, a different valuation of the asset, and so competing valuations can then be presented to the court. And certainly if the company itself has distributed the asset without, or the company's administrator or liquidator distributes the asset without obtaining an independent valuation by a reputable firm of valuers, I think that would raise all sorts of questions for the court, and I don't think the court will be able to approve that kind of distribution.